Hello, everyone. We're going to continue with SFFA v. Harvard, so we're wrapping up Justice Gorsuch's concurring opinion. In the aftermath of the Civil War, Congress took vital steps toward realizing the promise of equality under the law. As important as those initial efforts were, much work remained to be done, and much work remains today. But by any measure, the Civil Rights Act of 1964 stands as a landmark on this journey and one of the nation's great triumphs. We have no right to make a blank sheet of any of its provisions. And when we look to the clear and powerful command Congress set forth in that law, these cases all but resolve themselves. Under Title VI, it is never permissible to say yes to one person but to say no to another person, even in part because of the color of his skin. Justice Kavanaugh concurring. I join the court's opinion in full. I add this concurring opinion to further explain why the court's decision today is consistent with and follows from the court's equal protection precedents, including the court's precedents on race-based affirmative action in higher education. Ratified in 1868, in the wake of the Civil War, the Equal Protection Clause of the 14th Amendment provides, no state shall deny to any person within its jurisdiction the equal protection of the laws. In accord with the 14th Amendment's text and history, this court considers all racial classifications to be constitutionally suspect. As a result, the court has long held that racial classifications by the government, including race-based affirmative action programs, are subject to strict judicial scrutiny. Under strict scrutiny, racial classifications are constitutionally prohibited unless they are narrowly tailored to further a compelling governmental interest. Narrow tailoring requires courts to examine, among other things, whether a racial classification is necessary. In other words, whether race-neutral alternatives could adequately achieve the governmental interest. Importantly, even if a racial classification is otherwise narrowly tailored to further a compelling governmental interest, a deviation from the norm of equal treatment of all racial and ethnic groups must be a temporary matter, or stated otherwise, must be limited in time. In 1978, 5 members of this court held that race-based affirmative action in higher education did not violate the Equal Protection Clause or Title VI of the Civil Rights Act, so long as universities used race only as a factor in admissions decisions and did not employ quotas. One member of the court's 5-justice majority, Justice Blackmun, added that race-based affirmative action should exist only as a temporary measure. He expressed hope that such programs would be unnecessary and a relic of the past by 1988, within 10 years at the most, in his words, although he doubted that the goal could be achieved by then. In 2003, 25 years after Bakke, 5 members of this court again held that race-based affirmative action in higher education did not violate the Equal Protection Clause or Title VI. This time, however, the court also specifically indicated, despite the reservations of Justice Ginsburg and Justice Breyer, that race-based affirmative action in higher education would not be constitutionally justified after another 25 years, at least absent something not expected. And various members of the court wrote separate opinions explicitly referencing the court's 25-year limit. Justice O'Connor's opinion for the court stated, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Justice Thomas expressly concurred in the court's holding that racial discrimination in higher education admissions will be illegal in 25 years. Justice Thomas, joined here by Justice Scalia, reiterated the court's holding that race-based affirmative action in higher education will be unconstitutional in 25 years, and that in 25 years the practices of the law school will be illegal, while also stating that they are, for the reasons I have given, illegal now. Justice Kennedy referred to the court's pronouncement that race-conscious admissions programs will be unnecessary 25 years from now. Justice Ginsburg, joined by Justice Breyer, acknowledged the court's 25-year limit, but questioned it, writing that one may hope, but not firmly forecast, that over the next generation's span, progress toward non-discrimination and genuinely equal opportunity will make it safe to sunset affirmative action. In allowing race-based affirmative action in higher education for another generation, and only for another generation, the court in Grutter took into account competing considerations. The court recognized the barriers that some minority applicants to universities still faced as of 2003, notwithstanding the progress made since Bakke. The court stressed, however, that there are serious problems of justice connected with the idea of preference itself, and the court added that a core purpose of the 14th Amendment was to do away with all governmentally imposed discrimination based on race. The Grutter Court also emphasized the equal protection principle that racial classifications, even when otherwise permissible, must be a temporary matter and must be limited in time. The requirement of a time limit reflects that racial classifications, however compelling their goals, are potentially so dangerous that they may be employed no more broadly than the interest demands. Enshrining a permanent justification for racial preferences would offend this fundamental equal protection principle. Importantly, the Grutter Court saw no reason to exempt race-conscious admissions programs from the requirement that all governmental use of race must have a logical endpoint. The court reasoned that the requirement that all race-conscious admissions programs have a termination point assures all citizens that the deviation from the norm of equal treatment of all racial and ethnic groups is a temporary matter, a measure taken in the service of the goal of equality itself. The court therefore concluded that race-based affirmative action programs in higher education, like other racial classifications, must be limited in time. The Grutter Court's conclusion that race-based affirmative action in higher education must be limited in time followed not only from fundamental equal protection principles, but also from this court's equal protection precedents applying those principles. Under those precedents, racial classifications may not continue indefinitely. For example, in the elementary and secondary school context after Brown of the Board of Education, the court authorized race-based student assignments for several decades, but not indefinitely into the future. In those decisions, this court ruled that the race-based injunctions entered in school desegregation cases could not operate in perpetuity. Consistent with those decisions, the Grutter Court ruled that race-based affirmative action in higher education likewise could not operate in perpetuity. As of 2003, when Grutter was decided, many race-based affirmative action programs in higher education had been operating for about 25 to 35 years. Pointing to the court's precedents requiring that racial classifications be temporary, the petitioner in Grutter, joined by the United States, argued that race-based affirmative action in higher education could continue no longer. The Grutter Court rejected those arguments for ending race-based affirmative action in higher education in 2003, but in doing so, the court struck a careful balance. The court ruled that narrowly tailored race-based affirmative action in higher education could continue for another generation, but the court also explicitly rejected any permanent justification for racial preferences, and therefore ruled that race-based affirmative action in higher education could continue only for another generation. Harvard and North Carolina would prefer that the court now ignore or discard Grutter's 25-year limit on race-based affirmative action in higher education or treat it as a mere aspiration. But the 25-year limit constituted an important part of Justice O'Connor's nuanced opinion for the court in Grutter. Indeed, 4 of the separate opinions in Grutter discussed the majority opinion's 25-year limit, which belies any suggestion that the court's reference to it was insignificant or not carefully considered. In short, the court in Grutter expressly recognized the serious issues raised by racial classifications, particularly permanent or long-term racial classifications, and the court assured all citizens throughout America that the deviation from the norm of equal treatment in higher education could continue for another generation, and only for another generation. A generation has now passed since Grutter, and about 50 years have gone by since the era of Bakke and De Funes v. Odegaard, when race-based affirmative action programs in higher education largely began. In light of the Constitution's text, history, and precedent, the court's decision today appropriately respects and abides by Grutter's explicit temporal limit on the use of race-based affirmative action in higher education. Justice Sotomayor, Justice Kagan, and Justice Jackson disagree with the court's decision. I respect their views. They thoroughly recount the horrific history of slavery and Jim Crow in America, as well as the continuing effects of that history on African Americans today. And they are, of course, correct that for the last 5 decades, Bakke and Grutter have allowed narrowly tailored race-based affirmative action in higher education. But I respectfully part ways with my dissenting colleagues on the question of whether, under this court's precedents, race-based affirmative action in higher education may extend indefinitely into the future. The dissents suggest that the answer is yes, but this court's precedents make clear that the answer is no. To reiterate, for about 50 years, many institutions of higher education have employed race-based affirmative action programs. In the abstract, it might have been debatable how long those race-based admissions programs could continue under the temporary matter/limited in time equal protection principle recognized and applied by this court. But in 2003, the Grutter Court applied that temporal equal protection principle and resolved the debate. The court declared that race based affirmative action in higher education could continue for another generation, and only for another generation, at least absent something unexpected. As I have explained, the court's pronouncement of a 25-year period as both an extension of and an outer limit to race-based affirmative action in higher education formed an important part of the carefully constructed Grutter decision. I would abide by that temporal limit rather than discarding it, as today's dissents would do. To be clear, although progress has been made since Bakke and Grutter, racial discrimination still occurs and the effects of past racial discrimination still persist. Federal and state civil rights laws serve to deter and provide remedies for current acts of racial discrimination, and governments and universities still can, of course, act to undo the effects of past discrimination in many permissible ways that do not involve classification by race. See Justice Scalia concurring in judgment, and then the plurality opinion of O'Connor. In Crossan, the city has at its disposal a whole array of race-neutral devices to increase the accessibility of city contracting opportunities to small entrepreneurs of all races. In sum, the court's opinion today is consistent with and follows from the court's equal protection precedents, and I join the court's opinion in full. Justice Sotomayor, with whom Justice Kagan and Justice Jackson joined dissenting. The Equal Protection Clause of the 14th Amendment enshrines a guarantee of racial equality. The court long ago concluded that this guarantee can be enforced through race-conscious means in a society that is not and has never been colorblind. In Brown v. Board of Education, the court recognized the constitutional necessity of racially integrated schools in light of the harm inflicted by segregation and the importance of education to our democratic society. For 45 years, the court extended Brown's transformative legacy to the context of higher education, allowing colleges and universities to consider race in a limited way and for the limited purpose of promoting the important benefits of racial diversity. This limited use of race has helped equalize educational opportunities for all students of every race and background and has improved racial diversity on college campuses. Although progress has been slow and imperfect, race-conscious college admissions policies have advanced the Constitution's guarantee of equality and have promoted Brown's vision of a nation with more inclusive schools. Today, this court stands in the way and rolls back decades of precedent and momentous progress. It holds that race can no longer be used in a limited way in college admissions to achieve such critical benefits. In so holding, the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. The court subverts the constitutional guarantee of equal protection by further entrenching racial inequality in education, the very foundation of our democratic government and pluralistic society. Because the court's opinion is not grounded in law or fact and contravenes the vision of equality embodied in the 14th Amendment, I dissent. Equal educational opportunity is a prerequisite to achieving racial equality in our nation. From its founding, the United States was a new experiment in a republican form of government where democratic participation and the capacity to engage in self-rule were vital. At the same time, American society was structured around the profitable institution that was slavery, which the original Constitution protected. The Constitution initially limited the power of Congress to restrict the slave trade, accorded Southern states additional electoral power by counting 3/5 of their enslaved population in apportioning congressional seats, and gave enslavers the right to retrieve enslaved people who escaped to free states. Because a foundational pillar of slavery was the racist notion that black people are a subordinate class with intellectual inferiority, Southern states sought to ensure slavery's longevity by prohibiting the education of black people, whether enslaved or free. Thus, from this nation's birth, the freedom to learn was neither colorblind nor equal. With time, and at the tremendous cost of the Civil War, abolition came. More than 2 centuries after the first African enslaved persons were forcibly brought to our shores, Congress adopted the 13th Amendment to the Constitution, which abolished slavery and involuntary servitude except as a punishment for crime. Like all great historical transformations, emancipation was a movement, not a single event, owed to any single individual, institution, or political party. The fight for equal educational opportunity, however, was a key driver. Literacy was an instrument of resistance and liberation. Education provided the means to write a path to freedom and to learn of abolitionist activities. It allowed enslaved black people to disturb the power relations between master and slave, which fused their desire for literacy with their desire for freedom. Put simply, the very feeling of inferiority which slavery forced upon black people fathered an intense desire to rise out of their condition by means of education. Black Americans thus insisted, in the words of Frederick Douglass, that in a country governed by the people, like ours, education of the youth of all classes is vital to its welfare, prosperity, and to its existence. Black people's yearning for freedom of thought and for a more perfect union with educational opportunity for all played a crucial role during the Reconstruction era. Yet emancipation marked the beginning, not the end, of that era. Abolition alone could not repair centuries of racial subjugation. Following the 13th Amendment's ratification, the Southern states replaced slavery with a system of laws which imposed upon black people onerous disabilities and burdens and curtailed their rights in the pursuit of life, liberty, and property to such an extent that their freedom was of little value. Those so-called black codes discriminated against black people on the basis of race, regardless of whether they had been previously enslaved. Moreover, the criminal punishment exception in the 13th Amendment facilitated the creation of a new system of forced labor in the South. Southern states expanded their criminal laws, which in turn permitted involuntary servitude as a punishment for convicted black persons. States required, for example, that black people sign a labor contract to work for a white employer or face prosecution for vagrancy. State laws then forced black convicted persons to labor in plantations, mines, and industries in the South. This system of free forced labor provided tremendous benefits to Southern whites and was designed to intimidate, subjugate, and control newly emancipated black people. The 13th Amendment, without more, failed to equalize society. Congress thus went further and embarked on months of deliberation about additional Reconstruction laws. Those efforts included the appointment of a committee, the Joint Committee on Reconstruction, to inquire into the condition of the Confederate States. Among other things, the committee's report to Congress documented the deep-seated prejudice against emancipated black people in the Southern states and the lack of a general disposition to place the colored race, constituting at least 2/5 of the population, upon terms even of civil equality. In light of its findings, the committee proposed amending the Constitution to secure the equality of rights, civil and political. Congress acted on that recommendation and adopted the 14th Amendment. Proponents of the amendment declared that one of its key goals was to protect the black man in his fundamental rights as a citizen with the same shield which it throws over the white man. That is, the amendment sought to secure to a race recently emancipated, a race that through many generations was held in slavery, all the civil rights that the superior race enjoy. To promote this goal, Congress enshrined a broad guarantee of equality in the Equal Protection Clause of the amendment. That clause commands that no state shall deny to any person within its jurisdiction the equal protection of the laws. Congress chose its words carefully, opting for expansive language that focused on equal protection and rejecting proposals that would have made the Constitution explicitly colorblind. See, for example, a Congressional Globe 1287, rejecting proposed language providing that no state shall recognize any distinction between citizens on account of race or color. This choice makes it clear that the 14th Amendment does not impose a blanket ban on race-conscious policies. Simultaneously, with the passage of the 14th Amendment, Congress enacted a number of race-conscious laws to fulfill the amendment's promise of equality, leaving no doubt that the Equal Protection Clause permits consideration of race to achieve its goal. One such law was the Freedmen's Bureau Act, enacted in 1865 and then expanded in 1866, which established a federal agency to provide certain benefits to refugees and newly emancipated freedmen. For the Bureau, education was the foundation upon which all efforts to assist the freedmen rested. Consistent with that view, the Bureau provided essential funding for black education during Reconstruction. Black people were the targeted beneficiaries of the Bureau's programs, especially when it came to investments in education in the wake of the Civil War. Each year surrounding the passage of the 14th Amendment, the Bureau educated approximately 100,000 students, nearly all of them black, and regardless of degree of past disadvantage. The Bureau also provided land and funding to establish some of our nation's historically black colleges and universities, HBCUs. In 1867, for example, the Bureau provided Howard University tens of thousands of dollars to buy property and construct its campus in our nation's capital. Howard University was designed to provide special opportunities for a higher education to the newly enfranchised of the South, but it was available to all black people, whatever may have been their previous condition. The Bureau also expended a total of $407,752.21 on black colleges and only $3,000 on white colleges from 1867 to 1870. Indeed, contemporaries understood that the Freedmen's Bureau Act benefited black people. Supporters defended the law by stressing its race conscious approach. The true object of this bill is the amelioration of the condition of the colored people. Quoting Representative Moulton, and then the Joint Committee Report 11, reporting that the Union men of the South declared with one voice that the Bureau's efforts protected the colored people. Opponents argued that the act created harmful racial classifications that favored black people and disfavored white Americans. See Congressional Globe 397, Statement of Senator Wiley. The act makes a distinction on account of color between the two races. And then the statement of Representative Taylor. The act is legislation for a particular class of the blacks to the exclusion of all whites. And the statement of Representative Rousseau. You raise a spirit of antagonism between the black race and the white race in our country, and the law-abiding will be powerless to control it. President Andrew Johnson vetoed the bill on the basis that it provided benefits to a particular class of citizens. But Congress overrode his veto, thus rejecting those opponents' objections, and the same Reconstruction Congress that passed the 14th Amendment eschewed the concept of colorblindness as sufficient to remedy inequality in education. Congress also debated and passed the Civil Rights Act of 1866 contemporaneously with the 14th Amendment. The goal of that act was to eradicate the black codes enacted by Southern states following ratification of the 13th Amendment. Because the black codes focused on race, not just slavery-related status, the Civil Rights Act explicitly recognized that white citizens enjoyed certain rights that non-white citizens did not. Section 1 of the Act provided that all persons of every race and color shall have the same rights as those enjoyed by white citizens. Similarly, Section 2 established criminal penalties for subjecting racial minorities to different punishment by reason of color or race than is prescribed for the punishment of white persons. In other words, the act was not colorblind. By using white citizens as a benchmark, the law classified by race and took account of the privileges enjoyed only by white people. As he did with the Freedmen's Bureau Act, President Johnson vetoed the Civil Rights Act in part because he viewed it as providing black citizens with special treatment. See Messages and Papers 408 and at 408 and 413. The act is designed to afford discriminating protection to colored persons, and its distinction of race and color operates in favor of the colored and against the white race. Again, Congress overrode his veto. In fact, Congress reenacted race-conscious language in the Civil Rights Act of 1870, 2 years after ratification of the 14th Amendment. Congress similarly appropriated federal dollars explicitly and solely for the benefit of racial minorities. For example, it appropriated money for the relief of destitute colored women and children without regard to prior enslavement. Several times during and after the passage of the 14th Amendment, Congress also made special appropriations and adopted special protections for the bounty and prize money owed to colored soldiers and sailors of the Union Army. In doing so, it rebuffed objections to these measures as class legislation applicable to colored people and not to the white people. This history makes it inconceivable that race-conscious college admissions are unconstitutional. The Reconstruction era marked a transformational point in the history of American democracy. Its vision of equal opportunity leading to an equal society was short-lived, however, with the assistance of this court. In a series of decisions, the court sharply curtailed the substantive protections of the Reconstruction Amendments and the Civil Rights Acts. That endeavor culminated with the court's shameful decision in Plessy v. Ferguson, which established that equality of treatment exists when the races are provided substantially equal facilities, even though these facilities be separate. Therefore, with this court's approval, government enforced segregation and its concomitant destruction of equal opportunity became the constitutional norm and infected every sector of our society, from bathrooms to military units and, crucially, schools. In a powerful dissent, Justice Harlan explained in Plessy that the Louisiana law at issue, which authorized segregation in railway carriages, perpetuated a caste system. Although the state argued that the law prescribed a rule applicable alike to white and colored citizens, all knew that the law's purpose was not to exclude white persons from railroad cars occupied by blacks, but to exclude colored people from coaches occupied by or assigned to white persons. That is, the law proceeded on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens. Although the white race deems itself to be the dominant race in prestige, in achievements, in education, in wealth, and in power, Justice Harlan explained, there is no superior dominant ruling class of citizens in the eyes of the law. In that context, Justice Harlan thus announced his view that our Constitution is colorblind. It was not until half a century later, in Brown, that the court honored the guarantee of equality in the Equal Protection Clause and Justice Harlan's vision of a Constitution that neither knows nor tolerates classes among citizens. Considering the effects of segregation and the role of education in the light of its full development and its present place in American life throughout the nation, Brown overruled Plessy. The Brown Court held that separate educational facilities are inherently unequal, and that such racial segregation deprives black students of the equal protection of the laws guaranteed by the 14th Amendment. The court thus ordered segregated schools to transition to a racially integrated system of public education, with all deliberate speed, ordering the immediate admission of black children to schools previously attended only by white children. Brown was a race-conscious decision that emphasized the importance of education in our society. Central to the court's holding was the recognition that, as Justice Harlan emphasized in Plessy, segregation perpetuates a caste system wherein black children receive inferior educational opportunities solely because of their race, denoting inferiority as to their status in the community. Moreover, because education is the very foundation of good citizenship, segregation in public education harms our democratic society more broadly as well. In light of the harmful effects of entrenched racial subordination on racial minorities and American democracy, Brown recognized the constitutional necessity of a racially integrated system of schools where education is available to all on equal terms. The desegregation cases that followed Brown confirmed that the ultimate goal of that seminal decision was to achieve a system of integrated schools that ensured racial equality of opportunity, not to impose a formalistic rule of race blindness. In Green v. School Board of New Kent City, for example, the court held that the New Kent County of New Kent County. For example, the court held that the New Kent County School Board's Freedom of Choice plan, which allegedly allowed every student, regardless of race, freely to choose the school he would attend, was insufficient to effectuate the command of Brown. That command, the court explained, was that schools dismantle well-entrenched dual systems and transition to a unitary, non-racial system of public education. That the board opened the doors of the former white school to black children and the black school to white children on a race-blind basis was not enough. Passively eliminating race classifications did not suffice when de facto segregation persisted. See here at 440 and 442, noting that 85% of black children in the school system were still attending an all-black school. Instead, the board was clearly charged with the affirmative duty to take whatever steps might be necessary to convert to a unitary system in which racial discrimination would be eliminated root and branch. Affirmative steps, this court held, are constitutionally necessary when mere formal neutrality cannot achieve Brown's promise of racial equality. See North Carolina Board of Education v. Swan, holding that North Carolina statute that forbade the use of race in school busing exploits an apparently neutral form of neutral form to control school assignment plans by directing that they be colorblind. That requirement, against the background of segregation, would render illusory the promise of Brown. And Dayton Board of Education v. Brinkman, school board had to do more than abandon its prior discriminatory purpose. It had an affirmative responsibility to integrate. And Keys v. School District Number 1, Keys v. School District Number 1 of Denver, the state automatically assumes an affirmative duty under Brown to eliminate the vestiges of segregation. In so holding, this court's post-Brown decisions rejected arguments advanced by opponents of integration, suggesting that restoring race as a criterion in the operation of the public schools was at odds with the Brown decisions. Those opponents argued that Brown only required the admission of black students to public schools on a racially non-discriminatory basis. Relying on Justice Harlan's dissent in Plessy, they argued that the use of race is improper because the Constitution is colorblind. They also incorrectly claimed that their views aligned with those of the Brown litigators, arguing that the Brown plaintiffs understood that Brown's mandate was colorblindness. This court rejected that characterization of the thrust of Brown. It made clear that indifference to race is not an end in itself. Under that watershed decision, the ultimate goal is racial equality of opportunity. Those rejected arguments mirror the court's opinion today. The court claims that Brown requires that students be admitted on a racially non-discriminatory basis. It distorts the dissent in Plessy to advance a colorblindness theory. See Gorsuch concurring. In this opinion, today's decision wakes the echoes of Justice John Marshall Harlan in Plessy, and Justice Thomas concurring the same. The court also invokes the Brown litigators, relying on what the Brown plaintiffs had argued. If there was a member of this court who understood the Brown litigation, it was Justice Thurgood Marshall, who led the litigation campaign to dismantle segregation as a civil rights lawyer and rejected the hollow, race-ignorant conception of equal protection, endorsed by the court's ruling today. See the brief of the NAACP Legal Defense and Educational Fund as amici. Justice Marshall joined the Bakke plurality and applauded the judgment of the court that a university may consider race in its admissions process. In fact, Justice Marshall's view was that Bakke's holding should have been even more protective of race-conscious college admissions programs, in light of the remedial purpose of the 14th Amendment and the legacy of racial inequality in our society. See above at 396 and 402, arguing that a class-based remedy should be constitutionally permissible in light of the hundreds of years of class-based discrimination against Black Americans. The court's recharacterization of Brown is nothing but revisionist history and an affront to the legendary life of Justice Marshall, a great jurist who was a champion of true equal opportunity, not rhetorical flourishes about colorblindness. 2 decades after Brown in Bakke, a plurality of the court held that the attainment of a diverse student body is a compelling and constitutionally permissible goal for an institution of higher education. Race could be considered in the college admissions process in pursuit of this goal. The plurality explained if it is one factor of many in an applicant's file, and each applicant receives individualized review as part of a holistic admissions process. Since Bakke, the court has reaffirmed numerous times the constitutionality of limited race-conscious college admissions. First, in Grutter v. Bollinger, a majority of the court endorsed the Bakke plurality's view that student body diversity is a compelling state interest that can justify the use of race in university admissions, and held that race may be used in a narrowly tailored manner to achieve this interest. See also Gratz v. Bollinger. For the reasons set forth the same day in Grutter, rejecting the petitioner's arguments that race can only be considered in college admissions to remedy identified discrimination and that diversity is too open-ended, ill-defined, and indefinite to constitute a compelling interest. Later, in the Fisher litigation, the court twice reaffirmed that a limited use of race in college admissions is constitutionally permissible if it satisfies strict scrutiny. In Fisher v. University of Texas at Austin, Fisher 1, 7 members of the court concluded that the use of race in college admissions comports with the 14th Amendment if it is narrowly tailored to obtain the educational benefits of diversity. Several years later, in Fisher v. University of Texas at Austin, Fisher 2, the court upheld the admissions program at the University of Texas under this framework. Bakke, Grutter, and Fisher are an extension of Brown's legacy. Those decisions recognize that experience lends support to the view that the contribution of diversity is substantial. Racially integrated schools improve cross racial understanding, break down racial stereotypes, and ensure that students obtain the skills needed in today's increasingly global marketplace through exposure to widely diverse people, cultures, ideas, and viewpoints. More broadly, inclusive institutions that are visibly open to talented and qualified individuals of every race and ethnicity instill public confidence in the legitimacy and integrity of those institutions and the diverse set of graduates that they cultivate. That is particularly true in the context of higher education, where colleges and universities play a critical role in maintaining the fabric of society and serve as the training ground for a large number of our nation's leaders. It is thus an objective of the highest order, a compelling interest indeed, that universities pursue the benefits of racial diversity and ensure that the diffusion of knowledge and opportunity is available to students of all races. This compelling interest in student body diversity is grounded not only in the court's equal protection jurisprudence, but also in principles of academic freedom, which long have been viewed as a special concern of the First Amendment. In light of the important purpose of public education and the expansive freedoms of speech and thought associated with the university environment, this court's precedents recognize the imperative nature of diverse student bodies on American college campuses. Consistent with the First Amendment, student body diversity allows universities to promote the robust exchange of ideas, which discovers truth out of a multitude of tongues, rather than through any kind of authoritative selection. Indeed, as the court recently reaffirmed in another school case, learning how to tolerate diverse expressive activities has always been part of learning how to live in a pluralistic society under our constitutional tradition. Kennedy versus Bremerton School District, and then also Cormani v. Arizona with Gorsuch dissenting. Collecting research showing that larger juries are more likely to be racially diverse and deliberate longer, recall information better, and pay greater attention to dissenting voices. In short, for more than 4 decades, it has been this court's settled law that the Equal Protection Clause of the 14th Amendment authorizes a limited use of race in college admissions in service of the educational benefits that flow from a diverse student body. From Brown to Fisher, this court's cases have sought to equalize educational opportunity in a society structured by racial segregation and to advance the 14th Amendment's vision of an America where racially integrated schools guarantee students of all races the equal protection of the laws. Today, the court concludes that indifference to race is the only constitutionally permissible means to achieve racial equality in college admissions. That interpretation of the 14th Amendment is not only contrary to precedent and the entire teachings of our history, but is also grounded in the illusion that racial inequality was a problem of a different generation. Entrenched racial inequality remains a reality today. That is true for society writ large and, more specifically, for Harvard and the University of North Carolina, UNC, two institutions with a long history of racial exclusion. Ignoring race will not equalize a society that is racially unequal. What was true in the 1860s and again in 1954 is true today. Equality requires acknowledgement of inequality. After more than a century of government policies enforcing racial segregation by law, society remains highly segregated. About half of all Latino and Black students attend a racially homogeneous school with at least 75% minority student enrollment. The share of intensely segregated minority schools, i.e., schools that enroll 90% to 100% racial minorities, has sharply increased. To this day, the U.S. Department of Justice continues to enter into desegregation decrees with schools that have failed to eliminate the vestiges of de jure segregation. Moreover, underrepresented minority students are more likely to live in poverty and attend schools with a high concentration of poverty. When combined with residential segregation and school funding systems that rely heavily on local property taxes, this leads to racial minority students attending schools with fewer resources. See San Antonio Independent School District v. Rodriguez, with Justice Marshall dissenting, noting school funding disparities that result from local property taxation. In turn, underrepresented minorities are more likely to attend schools with less qualified teachers, less challenging curricula, lower standardized test scores, and fewer extracurricular activities, and advanced placement courses. It is thus unsurprising that there are achievement gaps along racial lines even after controlling for income differences. Systemic inequities disadvantaging underrepresented racial minorities exist beyond school resources. Students of color, particularly black students, are disproportionately disciplined or suspended, interrupting their academic progress and increasing their risk of involvement with the criminal justice system. Underrepresented minorities are less likely to have parents with a post-secondary education who may be familiar with the college application process. Further, low-income children of color are less likely to attend preschool and other early childhood education programs that increase educational attainment. All of these interlocked factors place underrepresented minorities multiple steps behind the starting line in the race for college admissions. In North Carolina, the home of UNC, racial inequality is deeply entrenched in K 12 education. State courts have consistently found that the state does not provide underrepresented racial minorities equal access to educational opportunities, and that racial disparities in public schooling have increased in recent years in violation of the state constitution. These opportunity gaps result in fewer students from underrepresented backgrounds even applying to college, particularly elite universities. Because talent lives everywhere, but opportunity does not, there are undoubtedly talented students with great academic potential who have simply not had the opportunity to attain the traditional indicia of merit that provide a competitive edge in the admissions process. Consistent with this reality, Latino and Black students are less likely to enroll in institutions of higher education than their white peers. Given the central role that education plays in breaking the cycle of racial inequality, these structural barriers reinforce other forms of inequality in communities of color. For example, Wilson, monopolizing whiteness. Educational opportunities allow for social mobility, better life outcomes, and the ability to participate equally in the social and economic life of the democracy. Stark racial disparities exist, for example, in unemployment rates, income levels, wealth and home ownership, and healthcare access. See also Shoot v. Bam, Justice Sotomayor dissenting, noting the persistent racial inequality in society. And then in Gratz with Justice Ginsburg dissenting, cataloging racial disparities in employment, poverty, healthcare, housing, consumer transactions, and education. Put simply, society remains inherently unequal. Racial inequality runs deep to this very day. That is particularly true in education, the most vital civic institution for the preservation of a democratic system of government. As I have explained before, only with eyes open to this reality can the court carry out the guarantee of equal protection. Both UNC and Harvard have sordid legacies of racial exclusion because context matters when reviewing race conscious college admissions programs. This reality informs the exigency of respondents' current admissions policies and their racial diversity goals. For much of its history, UNC was a bastion of white supremacy. Its leadership included slaveholders, the leaders of the Ku Klux Klan, the central figures in the white supremacy campaigns of 1898 and 1900, and many of the state's most ardent defenders of Jim Crow and race-based social Darwinism in the 20th century. The university excluded all people of color from its faculty and student body, glorified the institution of slavery, enforced its own Jim Crow regulations, and punished any dissent from racial orthodoxy. It resisted racial integration after this court's decision in Brown and was forced to integrate by court order in 1955. It took almost 10 more years for the first black woman to enroll at the university in 1963. Even then, the university admitted only a handful of underrepresented racial minorities, and those students suffered constant harassment, humiliation, and isolation. UNC officials openly resisted racial integration well into the 1980s, years after the youngest member of this court was born. During that period, black students faced racial epithets and stereotypes, received hate mail, and encountered Ku Klux Klan rallies on campus. To this day, UNC's deep-seated legacy of racial subjugation continues to manifest itself in student life. Buildings on campus still bear the names of members of the Ku Klux Klan and other white supremacist leaders. Students of color also continue to experience racial harassment, isolation, and tokenism. Plus, the student body remains predominantly white. Approximately 72% of UNC students identify as white, while only 8% identify as black. These numbers do not reflect the diversity of the state, particularly black North Carolinians, who make up 22% of the population. UNC is not alone. Harvard, like other Ivy League universities in our country, stood beside church and state as the third pillar of a civilization built on bondage. From Harvard's founding, slavery and racial subordination were integral parts of the institution's funding, intellectual production, and campus life. Harvard and its donors had extensive financial ties to and profited from the slave trade, the labor of enslaved people, and slavery related investments. As Harvard now recognizes, the accumulation of this wealth was vital to the university's growth and establishment as an elite national institution. Harvard suppressed anti-slavery views, and enslaved persons served Harvard presidents and professors and fed and cared for Harvard students on campus. Exclusion and discrimination continued to be a part of campus life well into the 20th century. Harvard's leadership and prominent professors openly promoted race science, racist eugenics, and other theories rooted in racial hierarchy. Activities to advance these theories took place on campus, including intrusive physical examinations and photographing of unclothed students. The university also prized the admission of academically able Anglo-Saxon students from elite backgrounds, including wealthy white sons of the South. By contrast, an average of 3 black students enrolled at Harvard each year during the 5 decades between 1890 and 1940. Those black students who managed to enroll at Harvard excelled academically, earning equal or better academic records than most white students, but faced the challenges of the deeply rooted legacy of slavery and racism on campus. Meanwhile, a few women of color attended Radcliffe College, a separate and overwhelmingly white women's annex where racial minorities were denied campus housing and scholarships. Women of color at Radcliffe were taught by Harvard professors, but women did not receive Harvard degrees until 1963. See Upending the Ivory Tower, Civil Rights, Black Power, and the Ivy League, noting that the historical discussion of racial integration at the Ivy League is necessarily male-centric, given the historical exclusion of women of color from these institutions. Today, benefactors with ties to slavery and white supremacy continue to be memorialized across campus through statues, buildings, professorships, student houses, and the like. Black and Latino applicants account for only 20% of domestic applicants to Harvard each year. Even those students of color who beat the odds and earn an offer of admission continue to experience isolation and alienation on campus. For years, the university has reported that inequities on campus remain. For example, Harvard has reported that far too many black students at Harvard experience feelings of isolation and marginalization, and that student survey data showed that only half of Harvard undergraduates believe that the housing system fosters exchanges between students of different backgrounds. These may be uncomfortable truths to some, but they are truths nonetheless. Institutions can and do change, however, as societal and legal changes force them to live up to their highest ideals. It is against this historical backdrop that Harvard and UNC have reckoned with their past and its lingering effects. Acknowledging the reality that race has always mattered and continues to matter, these universities have established institutional goals of diversity and inclusion. Consistent with equal protection principles and this court's settled law, their policies use race in a limited way with the goal of recruiting, admitting, and enrolling underrepresented racial minorities to pursue the well-documented benefits of racial integration in education. The court today stands in the way of respondents' commendable undertaking and entrenches racial inequality in higher education. The majority opinion does so by turning a blind eye to these truths and overruling decades of precedent, content for now to disguise its ruling as an application of established law and move on. As Justice Thomas put it, Grutter is, for all intents and purposes, overruled. It is a disturbing feature of today's decision that the court does not even attempt to make the extraordinary showing required by stare decisis. The court simply moves the goalposts, upsetting settled expectations and throwing admissions programs nationwide into turmoil. In the end, however, it is clear why the court is forced to change the rules of the game to reach its desired outcome. Under a faithful application of the court's settled legal framework, Harvard and UNC's admissions programs are constitutional and comply with Title VI of the Civil Rights Act of 1964. Answering the question whether Harvard's and UNC's policies survive strict scrutiny under settled law is straightforward, both because of the procedural posture of these cases and because of the narrow scope of the issues presented by petitioners' Students for Fair Admissions, Incorporated, SFFA. These cases arrived at this court after 2 lengthy trials. Harvard and UNC introduced dozens of fact witnesses, expert testimony, and documentary evidence in support of their admissions programs. SFFA, by contrast, did not introduce a single fact witness and relied on the testimony of 2 experts. After making detailed findings of fact and conclusions of law, the district courts entered judgment in favor of Harvard and UNC. The First Circuit affirmed in the Harvard case, finding no error in the district court's thorough opinion. SFFA then filed petitions for a writ of certiorari in both cases, which the court granted. The court granted certiorari on 3 questions. 1. Whether the court should overrule Bakke, Grutter, and Fisher, or alternatively 2. Whether UNC's admissions program is narrowly tailored, and 3. Whether Harvard's admissions program is narrowly tailored. Answering the last 2 questions, which call for application of settled law to the facts of these cases, is simple. Deferring to the lower court's careful findings of fact and credibility determinations, Harvard's and UNC's policies are narrowly tailored. As to narrow tailoring, the only issue SFFA raises in the UNC case is that the university cannot use race in its admissions process because race-neutral alternatives would promote UNC's diversity objectives. That issue is so easily resolved in favor of USC that SFFA devoted only 3 pages to it at the end of its 87-page brief. The use of race is narrowly tailored unless workable. The use of race is narrowly tailored unless workable and available race-neutral approaches exist, meaning race-neutral alternatives promote the institution's diversity goals and do so at tolerable administrative expense. Narrow tailoring does not mean perfect tailoring. The court's precedents make clear that narrow tailoring does not require exhaustion of every conceivable race-neutral alternative, nor does it require a university to choose between maintaining a reputation for excellence or fulfilling a commitment to provide educational opportunities to members of all racial groups. As the district court found after considering extensive expert testimony, SFFA's proposed race-neutral alternatives do not meet those criteria. All of SFFA's proposals are methodologically flawed because they rest on terribly unrealistic assumptions about the applicant pools. For example, as to one set of proposals, SFFA's expert unrealistically assumed that all of the top students in the candidate pool he used would apply, be admitted, and enroll. In addition, some of SFFA's proposals forced UNC to abandon its holistic approach to college admissions, a result in deep tension with the goal of educational diversity as this court's cases have defined it. Others are largely impractical, not to mention unprecedented, in higher education. SFFA's proposed top percentage plans, for example, are based on a made-up and complicated admissions index that requires UNC to access real-time data for all high school students. UNC is then supposed to use that index, which would change every time any student took a standardized test, to rank students based on grades and test scores. One of SFFA's top percentage plans would even nearly erase the Native American incoming class at UNC. The courts below correctly concluded that UNC is not required to adopt SFFA's unrealistic proposals to satisfy strict scrutiny. Harvard's admissions program is also narrowly tailored under settled law. SFFA argues that Harvard's program is not narrowly tailored because the university has workable race-neutral alternatives, does not use race as a mere plus, and engages in racial balancing. As the First Circuit concluded, there was no error in the district court's findings on any of these issues. Like UNC, Harvard has already implemented many of SFFA's proposals, such as increasing recruitment efforts and financial aid for low-income students. Also like UNC, Harvard carefully considered other race-neutral ways to achieve its diversity goals, but none of them are workable. SFFA's argument before this court is that Harvard should adopt a plan designed by SFFA's expert for purposes of trial, which increases preferences for low-income applicants and eliminates the use of race and legacy preferences. Under SFFA's model, however, black representation would plummet to around 32%, and the admitted share of applicants with high academic ratings would decrease, as would the share of high extracurricular and athletic ratings. SFFA's proposal, echoed by Justice Gorsuch, requires Harvard to make sacrifices on almost every dimension important to its admissions process, and forces it to choose between a diverse student body and a reputation for academic excellence. Neither this court's precedents nor common sense impose that type of burden on colleges and universities. The courts below also properly reject SFFA's argument that Harvard does not use race in the limited way this court's precedents allow. The court has explained that a university can consider a student's race in its admissions process so long as that use is contextual and does not operate as a mechanical plus factor. The court has also repeatedly held that race, when considered as one factor of many in the context of holistic review, can make a difference to whether an application is accepted or rejected. After all, race-conscious admissions seek to improve racial diversity. Race cannot, however, be decisive for virtually every minimally qualified underrepresented minority applicant. That is precisely how Harvard's program operates. In recent years, Harvard has received about 35,000 applications for a class with about 1,600 seats. The admissions process is exceedingly competitive. It involves 6 different application components. Those components include interviews with alumni and admissions officers, as well as consideration of a whole range of information such as grades, test scores, recommendation letters, and personal essays by several committees. Consistent with that individualized, holistic review process, admissions officers may, but need not, consider a student's self-reported racial identity when assigning overall ratings. Even after so many layers of competitive review, Harvard typically ends up with about 2,000 tentative admits, more students than the 1,600 or so that the university can admit. To choose among those highly qualified candidates, Harvard considers plus factors which can help tip an applicant into Harvard's admitted class. To diversify its class, Harvard awards tips for a variety of reasons, including geographic factors, socioeconomic status, ethnicity, and race. There is no evidence of any mechanical use of tips. Consistent with the court's precedents, Harvard properly considers race as part of a holistic review process, values all types of diversity, does not consider race exclusively, and does not award a fixed amount of points to applicants because of their race. Indeed, Harvard's admissions process is so competitive and the use of race is so limited and flexible that, as SFFA's own expert analysis showed, Harvard rejects more than 2/3 of Hispanic applicants and slightly less than half of all African American applicants, who are among the top 10% most academically promising applicants. The courts below correctly rejected SFFA's view that Harvard's use of race is unconstitutional because it impacts overall Hispanic and Black student representation by 45%. That 45% figure shows that eliminating the use of race in admissions would reduce African American representation from 14% to 6% and Hispanic representation from 14% to 9%. Such impact of Harvard's limited use of race on the makeup of the class is less than this court has previously upheld as narrowly tailored. In Grutter, for example, eliminating the use of race would have reduced the underrepresented minority population by 72%, a much greater effect. And in Fisher, too, the use of race helped increase Hispanic representation from 11% to 16.9%. A 54% increase, and African American representation from 3.5% to 6.8%, a 94% increase. Finally, the courts below correctly concluded that Harvard complies with this court's repeated admonition that colleges and universities cannot define their diversity interest as some specified percentage of a particular group merely because of its race or ethnic origin. Harvard does not specify its diversity objectives in terms of racial quotas, and SFFA did not offer expert testimony to support its racial balancing claim. Harvard's statistical evidence, by contrast, showed that the admitted classes across racial groups varied considerably year to year, a pattern inconsistent with the imposition of a racial quota or racial balancing. Similarly, Harvard's use of one-pagers containing a snapshot of various demographic characteristics of Harvard's applicant pool during the admissions review process is perfectly consistent with this court's precedents. Consultation of these reports with no specific number firmly in mind does not transform Harvard's program into a quota. Rather, Harvard's ongoing review complies with the court's command that universities periodically review the necessity of the use of race in their admissions programs. The court ignores these careful findings and concludes that Harvard engages in racial balancing because its focus on numbers is obvious. Because SFFA failed to offer an expert and to prove its claim below, the majority is forced to reconstruct the record and conduct its own factual analysis. It thus relies on a single chart from SFFA's brief that truncates relevant data in the record. That chart cannot displace the careful fact-finding by the district court, which the First Circuit upheld on appeal under clear error review. In any event, the chart is misleading and ignores the broader context of the underlying data that it purports to summarize. As the First Circuit concluded, what the data actually show is that admissions have increased for all racial minorities, including Asian American students, whose admissions numbers have increased roughly fivefold since 1980 and roughly twofold since 1990. The data also show that the racial shares of admitted applicants fluctuate more than the corresponding racial shares of total applicants, which is the opposite of what one would expect if Harvard imposed a quota. Even looking at the court's truncated period of the classes of 2009 to 2018, the same pattern holds. The fact that Harvard's racial shares of admitted applicants varies relatively little in absolute terms for those classes is unsurprising and reflects the fact that the racial makeup of Harvard's applicant pool also varies very little over this period. Thus, properly understood, the data show that Harvard does not utilize quotas and does not engage in racial balancing. The court concludes that Harvard's and UNC's policies are unconstitutional because they serve objectives that are insufficiently measurable, employ racial categories that are imprecise and overbroad, rely on racial stereotypes and disadvantage non-minority groups, and do not have an endpoint. In reaching this conclusion, the court claims those supposed issues with respondents' programs render the programs insufficiently narrow under the strict scrutiny framework that the court's precedents command. In reality, however, the court today cuts through the kudzu and overrules its higher education precedents following Bakke. Quoting Justice Gorsuch, there is no better evidence than the court is overruling the court's precedents than those precedents themselves. Every one of the arguments made by the majority can be found in the dissenting opinions filed in the cases the majority now overrules. C. Payne v. Tennessee, Justice Marshall dissenting, and then C, for example, Grutter, Justice Thomas, concurring in part and dissenting in part. Unlike the majority, I seek to define with precision the interest being asserted. And then Fisher 2, with Thomas dissenting, race-conscious admissions, programs rest on pernicious assumptions about race. And then Alito, joined by Chief Justice Roberts and Thomas dissenting, diversity interests are laudable goals, but they are not concrete or precise. And then race-conscious college admissions plan discriminates against Asian American students, and race-conscious admissions plan is unconstitutional because it does not specify what it means to be African American, Hispanic, Asian American, Native American, or white. Race-conscious college admissions policies rest on pernicious stereotypes. Lost arguments are not grounds to overrule a case. When proponents of those arguments, greater now in number, on the court return to fight old battles anew, it betrays an unrestrained disregard for precedent. It fosters the people's suspicions that bedrock principles are founded in the proclivities of individuals on this court, not in the law, and it degrades the integrity of our constitutional system of government. Nowhere is the damage greater than in cases like these that touch upon matters of representation and institutional legitimacy. The court offers no justification, much less a special justification, for its costly endeavor. Nor could it. There is no basis for overruling Bakke, Grutter, and Fisher. The court's precedents were correctly decided. The opinion today is not workable and creates serious equal protection problems. Important reliance interests favor respondents, and there are no legal or factual developments favoring the court's reckless course. At bottom, the 6 unelected members of today's majority upend the status quo based on their policy preferences about what race in America should be like, but is not, and their preferences for a veneer of colorblindness in a society where race has always mattered and continues to matter in fact and in law. A limited use of race in college admissions is consistent with the 14th Amendment and this court's broader equal protection jurisprudence. The text and history of the 14th Amendment make clear that the Equal Protection Clause permits race conscious measures. Consistent with that view, the court has explicitly held that race based action is sometimes within constitutional constraints. The court has thus upheld the use of race in a variety of contexts. See, for example, parents involved in community schools versus Seattle School District Number 1. The obligation to disestablish a school system segregated by law can include race conscious remedies, whether or not a court had issued an order to that effect. And then Johnson v. California, use of race permissible to further prisons' interest in security and discipline. And Cooper v. Harris, use of race permissible when drawing voting districts in some circumstances. Tellingly, in sharp contrast with today's decision, the court has allowed the use of race when that use burdens minority populations. In United States versus Brignoni-Ponce, for example, the court held that it is unconstitutional for Border Patrol agents to rely on a person's skin color as a single factor to justify a traffic stop based on reasonable suspicion, but it remarked that Mexican appearance could be a relevant factor out of many to justify such a stop at the border and its functional equivalents. See here at 882, recognizing that the border includes entire metropolitan areas such as San Diego, El Paso, and the South Texas Rio Grande Valley. The court thus facilitated racial profiling of Latinos as a law enforcement tool and did not adopt a race-blind rule. The court later extended this reasoning to Border Patrol agents selectively referring motorists for secondary inspection at a checkpoint, concluding that even if it be assumed that such referrals are made largely on the basis of apparent Mexican ancestry, there is no constitutional violation. The result of today's decision is that a person's skin color may play a role in assessing individualized suspicion, but it cannot play a role in assessing that person's individualized contributions to a diverse learning environment. That indefensible reading of the Constitution is not grounded in law and subverts the 14th Amendment's guarantee of equal protection. The majority does not dispute that some uses of race are constitutionally permissible. Indeed, it agrees that a limited use of race is permissible in some college admissions programs. In a footnote, the court exempts military academies from its ruling in light of the potentially distinct interests they may present. To the extent the court suggests national security interests are distinct, those interests cannot explain the court's narrow exemption, as national security interests are also implicated at civilian universities. The court also attempts to justify its carve-out based on the fact that no military academy is a party to these cases. Yet the same can be said of many other institutions that are not parties here, including the religious universities supporting respondents, which the court does not similarly exempt from its sweeping opinion. See the Georgetown brief. Catholic colleges and universities noting that they rely on the use of race in their holistic admissions to further not just their academic goals, but also their religious missions. And then Harvard, too. Schools that consider race are diverse on numerous dimensions, including in terms of religious affiliation, location, size, and courses of study offered. The court's carve-out only highlights the arbitrariness of its decision and further proves that the 14th Amendment does not categorically prohibit the use of race in college admissions. The concurring opinions also agree that the Constitution tolerates some racial classifications. Justice Gorsuch agrees with the majority's conclusion that racial classifications are constitutionally permissible if they advance a compelling interest in a narrowly tailored way. Justice Kavanaugh, too, agrees that the Constitution permits the use of race if it survives strict scrutiny. Justice Thomas offers an originalist defense of the colorblind Constitution, but his historical analysis leads to the inevitable conclusion that the Constitution is not, in fact, colorblind. Like the majority, Justice Thomas agrees that race can be used to remedy past discrimination and to equalize treatment against a concrete baseline of government imposed inequality. He also argues that race can be used if it satisfies strict scrutiny more broadly, and he considers compelling interests those that prevent anarchy, curb violence, and segregate prisoners. Thus, although Justice Thomas at times suggests that the Constitution only permits directly remedial measures that benefit identified victims of discrimination, he agrees that the Constitution tolerates a much wider range of race conscious measures. In the end, when the court speaks of a colorblind constitution, it cannot really mean it, for it is faced with a body of law that recognizes that race conscious measures are permissible under the Equal Protection Clause. Instead, what the court actually lands on is an understanding of the Constitution that is colorblind sometimes, when the court so chooses. Behind those choices lie the court's own value judgments about what type of interests are sufficiently compelling to justify race conscious measures. Overruling decades of precedent, today's newly constituted court singles out the limited use of race in holistic college admissions. It strikes at the heart of Bakke, Grutter, and Fisher by holding that racial diversity is an inescapably imponderable objective that cannot justify race-conscious affirmative action, even though respondents' objectives simply mirror the compelling interest this court has approved many times in the past. See, for example, UNC, the university's admissions policy repeatedly cites Supreme Court precedents as guideposts. At bottom, without any new factual or legal justification, the court overrides its longstanding holding that diversity in higher education is of compelling value. To avoid public accountability for its choice, the court seeks cover behind a unique measurability requirement of its own creation. None of this court's precedents, however, require that a compelling interest meet some threshold level of precision to be deemed sufficiently compelling. In fact, this court has recognized as compelling plenty of interests that are equally or more amorphous, including the intangible interest in preserving public confidence in judicial integrity, an interest that does not easily reduce to precise definition. And then see Ramirez v. Collier. With Chief Justice Roberts for the court, maintaining solemnity and decorum in the execution chamber is a compelling interest. And United States v. Alvarez, protecting the integrity of the Medal of Honor is a compelling interest. Sable Communications of California v. FCC, protecting the physical and psychological well-being of minors is a compelling interest. Thus, although the members of this majority pay lip service to respondents' commendable and worthy racial diversity goals, they make a clear value judgment today. Racial integration in higher education is not sufficiently important to them. Today, the proclivities of individuals rule. The majority offers no response to any of this. Instead, it attacks a straw man, arguing that the court's cases recognize that remedying the effects of societal discrimination does not constitute a compelling interest. Yet, as the majority acknowledges, while Bakke rejected that interest as insufficiently compelling, it upheld a limited use of race in college admissions to promote the educational benefits that flow from diversity. It is that narrower interest which the court has reaffirmed numerous times since Bakke, and as recently as 2016 in Fisher 2, that the court overrules today. The court's precedents authorizing a limited use of race in college admissions are not just workable, they have been working. Lower courts have consistently applied them without issue, as exemplified by the opinions below and SFFA's and the court's inability to identify any split of authority. Today, the court replaces this settled framework with a set of novel restraints that create troubling equal protection problems and share one common purpose: to make it impossible to use race in a holistic way in college admissions where it is much needed. The court argues that Harvard's and UNC's programs must end because they unfairly disadvantage some racial groups. According to the court, college admissions are a zero-sum game, and respondents' use of race unfairly advantages underrepresented minority students at the expense of other students. That is not the role race plays in holistic admissions. Consistent with the court's precedents, respondents' holistic review policies consider race in a very limited way. Race is only one factor out of many. That type of system allows Harvard and UNC to assemble a diverse class on a multitude of dimensions. Respondents' policies allow them to select students with various unique attributes, including talented athletes, artists, scientists, and musicians. They also allow respondents to assemble a class with diverse viewpoints, including students who have different political ideologies and academic interests, who have struggled with different types of disabilities, who are from various socioeconomic backgrounds, who understand different ways of life in various parts of the country, and yes, students who self identify with various racial backgrounds and who can offer different perspectives because of that identity. That type of multidimensional system benefits all students. In fact, racial groups that are not underrepresented tend to benefit disproportionately from such a system. Harvard's holistic system, for example, provides points to applicants who qualify as ALDC, meaning athletes, legacy applicants, applicants on the dean's interest list, primarily relatives of donors, and children of faculty or staff. See Harvard 2, noting also that SFFA does not challenge the admission of this large group. ALDC applicants are predominantly white, around 67.8% are white, 11.4% are Asian American, 6% are black, and 5.6% are Latino. By contrast, only 40.3% of non ALDC applicants are white, 28.3% are Asian American, 11% are black, and 12.6% are Latino. Although ALDC applicants make up less than 5% of applicants to Harvard, they constitute around 30% of the applicants admitted each year. Similarly, because of achievement gaps that result from entrenched racial inequality in K 12 education, a heavy emphasis on grades and standardized test scores disproportionately disadvantages underrepresented racial minorities. Stated simply, race is one small piece of a much larger admissions puzzle where most of the pieces disfavor underrepresented racial minorities. That is precisely why underrepresented racial minorities remain underrepresented. The court's suggestion that an already advantaged racial group is disadvantaged because of a limited use of race is a myth. The majority's true objection appears to be that a limited use of race in college admissions does, in fact, achieve what it is designed to achieve. It helps equalize opportunity and advances respondents' objectives by increasing the number of underrepresented racial minorities on college campuses, particularly Black and Latino students. This is unacceptable, the court says, because racial groups that are not underrepresented would be admitted in greater numbers without these policies. Reduced to its simplest terms, the court's conclusion is that an increase in the representation of racial minorities at institutions of higher learning that were historically reserved for white Americans is an unfair and repugnant outcome that offends the Equal Protection Clause. It provides a license to discriminate against white Americans, the court says, which require the courts and state actors to pick the right races to benefit. Nothing in the 14th Amendment or its history supports the court's shocking proposition, which echoes arguments made by opponents of Reconstruction era laws and this court's decision in Brown. In a society where opportunity is dispensed along racial lines, racial equality cannot be achieved without making room for underrepresented groups that for far too long were denied admission through the force of law, including at Harvard and UNC. Quite the opposite. A racially integrated vision of society in which institutions reflect all sectors of the American public and where the sons of former slaves and the sons of former slave owners are able to sit down together at the table of brotherhood is precisely what the Equal Protection Clause commands. Martin Luther King, I Have a Dream speech, August 28th, 1963. It is essential if the dream of one nation, indivisible, is to be realized. By singling out race, the court imposes a special burden on racial minorities for whom race is a crucial component of their identity. Holistic admissions require truly individualized consideration of the whole person. Yet, by foreclosing racial considerations, colorblindness denies those who racially self-identify the full expression of their identity and treats racial identity as inferior among all forms of society, among all other forms of society. The court's approach thus turns the 14th Amendment's equal protection guarantee on its head and creates an equal protection problem of its own. There is no question that minority students will bear the burden of today's decision. Students of color testified at trial that racial self-identification was an important component of their application because without it, they would not be able to present a full version of themselves. For example, Ramel Mwamba, a black UNC alumna, testified that it was really important that UNC see who she is. A black UNC alumna testified that it was really important that UNC see who she is holistically and how the color of her skin and the texture of her hair impacted her upbringing. Itzel Vasquez Rodriguez, who identifies as Mexican American of Cora descent, testified that her ethno-racial identity is a core piece of who she is and has impacted every experience she has had, such that she could not explain her potential contributions to Harvard without any reference to it. Sally Chen, a Harvard alumna who identifies as Chinese American, explained that being the child of Chinese immigrants was really fundamental to explaining who she is. Thang Deep, a Harvard alumnus, testified that his Vietnamese identity was such a big part of himself that he needed to discuss it in his application. And Sarah Cole, a Black Harvard alumna, emphasized that to try to not see her race is to try to not see her simply because there is no part of her experience, no part of her journey, no part of her life that has been untouched by her race. In a single paragraph at the end of its lengthy opinion, the court suggests that nothing in today's opinion prohibits universities from considering a student's essay that explains how race affected that student's life. This supposed recognition that universities can, in some situations, consider race in application essays is nothing but an attempt to put lipstick on a pig. The court's opinion circumscribes universities' ability to consider race in any form by meticulously gutting respondents' asserted diversity interests. Yet, because the court cannot escape the inevitable truth that race matters in students' lives, it announces a false promise to save face and appear attuned to reality. No one is fooled. Further, the courts demand that a student's discussion of racial self-identification be tied to individual qualities such as courage, leadership, unique ability, and determination only serves to perpetuate the false narrative that Harvard and UNC currently provide preferences on the basis of race alone. See the opinion at 28 and 29 and 39, claiming without support that race alone explains the admissions decisions for hundreds, if not thousands, of applicants. The court's precedents already require that universities take race into account holistically, in a limited way, and based on the type of individualized and flexible assessments that the court purports to favor. See the Harvard College brief, describing how the dozens of application files in the record uniformly show that, in line with Harvard's whole person admissions philosophy, Harvard's admissions officers engage in a highly nuanced assessment of each applicant's background and qualifications. After extensive discovery and 2 lengthy trials, neither SFFA nor the majority can point to a single example of an underrepresented racial minority who was admitted to Harvard or UNC on the basis of race alone. In the end, the court merely imposes its preferred college application format on the nation, not acting as a court of law applying precedent, but taking on the role of college administrators to decide what is better for society. The court's course reflects its inability to recognize that racial identity informs some students' viewpoints and experiences in unique ways. The court goes as far as to claim that Baki's recognition that Black Americans can offer different perspectives than white people amounts to a stereotype. It is not a stereotype to acknowledge the basic truth that young people's experiences are shaded by a societal structure where race matters. Acknowledging that there is something special about a student of color who graduates valedictorian from a predominantly white school is not a stereotype, nor is it a stereotype to acknowledge that race imposes certain burdens on students of color that it does not impose on white students. For generations, Black and brown parents have given their children the talk, instructing them never to run down the street, always keep your hands where they can be seen, do not even think of talking back to a stranger, all out of fear of how an officer with a gun will react to them. Those conversations occur regardless of socioeconomic background or any other aspect of a student's self-identification. They occur because of race. As Andrew Brennan, a UNC alumnus, testified, running down the neighborhood, people don't see him as someone that is relatively affluent. They see him as a Black man. The absence of racial diversity, by contrast, actually contributes to stereotyping. Diminishing the force of such stereotypes is both a crucial part of respondents' mission and one that they cannot accomplish with only token numbers of minority students. When there is an increase in underrepresented minority students on campus, racial stereotypes lose their force, because diversity allows students to learn there is no minority viewpoint, but rather a variety of viewpoints among minority students. By preventing respondents from achieving their diversity objectives, it is the court's opinion that facilitates stereotyping on American college campuses. To be clear, today's decision leaves intact holistic college admissions and recruitment efforts that seek to enroll diverse classes without using racial classifications. Universities should continue to use those tools as best they can to recruit and admit students from different backgrounds, based on all the other factors the court's opinion does not and cannot touch. Colleges and universities can continue to consider socioeconomic diversity and to recruit and enroll students who are first generation college applicants or who speak multiple languages, for example. Those factors are not interchangeable with race. See, for example, Laura Ornelas, a UNC alumna, testifying that her Latina identity, socioeconomic status, and first generation college status are all important but different parts of getting a full picture of who she is and how she sees the world. At SFFA's own urging, those efforts remain constitutionally permissible. See the brief for petitioner, emphasizing race neutral alternatives that Harvard and UNC should implement, such as those that focus on socioeconomic and geographic diversity, percentage plans, plans that increase community college transfers, and plans that develop partnerships with disadvantaged high schools. And Justice Thomas concurring, arguing universities can consider race neutral policies similar to those adopted in states such as California and Michigan, and that universities can consider status as a first generation college applicant, financial means, and generational inheritance or otherwise. And then see Justice Kavanaugh concurring, citing SFFA's briefs and concluding that universities can use race neutral means, and Justice Gorsuch recounting what SFFA has argued every step of the way as to race-neutral tools. The court today also does not adopt SFFA's suggestion that college admissions should be a function of academic metrics alone. Using class rank or standardized test scores as the only admissions criteria would severely undermine multidimensional diversity in higher education. Such a system would exclude the star athlete or musician whose grades suffered because of daily practices and training. It would exclude a talented young biologist who struggled to maintain above average grades in humanities classes. And it would exclude a student whose freshman year grades were poor because of a family crisis, but who got herself back on track in her last 3 years of school, only to find herself just outside of the top decile of her class. A myopic focus on academic ratings does not lead to a diverse student body. And we'll stop there for today. And as always, if there's any case you'd like me to read, just drop in the comments. I'd be happy to take a look. Thank you.